Criminal justice isn't simple, and it's not simplistic, and that's what this bill is. And I found it a little hard to listen to the Minister talking about how his government is allegedly making progress on a target to reduce victims of serious crime, of violent crime, by 20,000, when in fact they've gone up by 6,000, and the best he can do is find a tweet with some misleading figures to trumpet his government's success. This bill is a knee-jerk reaction. And look, in other areas we are supporting the government's work, particularly around the experience of victims in court, and we agree that there's work to be done. We need to do better in looking after victims. But sentencing in particular is a very difficult task. The community does want to see punishment, but the state and the court has a critical role in standing between victim and offender, between the community and the offender, and balancing a whole lot of competing interests. And that is why we have judges who can stand back, listen carefully, and balance those competing considerations. And the Minister, straight out of the National Party election playbook, talks about real consequences for crime. But when we look at sentencing, we've got to ask, what are the objectives? And they're in fact set out in the Act. And they're in no particular order, but right up there is to hold the offender accountable, as well as to provide for the interests of the victim of the offence. But equally in there is to assist in rehabilitation and reintegration, to protect the community from the offender if necessary. Taking that all in Section 7 of the Sentencing Act, if we take that together, criminal justice has a difficult and complex project of creating, not only of dealing with this offender, but creating a community in the future which is safer than the one we have today. And this doesn't do that. Most fundamentally, this doesn't do that, because it removes from the judge the ability to weigh up what the best response to offending is. Sometimes the offending is serious and the offender is irredeemable, or the crime so vicious and violent that the community needs it to be marked out by a long term of imprisonment. I get that. In other circumstances, that is not the case. The offender and the community, the offender will be better off, the victim's needs will be better addressed, and the community will be safer if a different sentence is imposed, or a shorter period of imprisonment, or better reintegration or rehabilitation, or home detention, or alcohol and drug treatment. There's a whole world of possible responses out there, but this government is saying, no, just put them in prison for longer. And that is the extent of their thinking around justice policy. And the Justice Select Committee, as it listened to submitters and looked at evidence, had a stream of thoughtful submitters coming in and saying, this is taking the wrong path. But the government was not interested in it, and consistent with what it's done in other areas, it's just saying, we've said we're going to do it, we don't care about the evidence, so we will press on regardless. One of the real problems with this is that it will distort judges' behaviour. The judges through many years have a set of guiding principles for sentencing, and one of those is assessing a starting point, looking at the circumstances of offending and saying, well, given those circumstances of offending, the starting point for consideration of the sentence is here. So it might be a serious assault with a 10-year maximum sentence. They'll look at the overall circumstances and say, well, for this kind of offending, I would start at 7 years and then apply discount. And it's worked. That process has worked, and aggravating factors as well. And what we now have is a rule that says you can get a maximum discount of 40% from the starting point. So if a judge wants to give a lower sentence, what are they going to do? They're simply going to lower the starting point. There's no rule against lowering the starting point. They're going to look at it, they're going to backwards reason. That offending deserves imprisonment of 3 years. To get that 40%, within the 40% discount rule, I need to lower the starting point accordingly. So all of a sudden, and this is what fiddling with these kinds of matters does, particularly in reducing discretion, they'll just get a workaround. The other thing, that's one problem. The other thing that I'm actually more concerned about is discharges without conviction. Now, there's no particular rule about when or what kind of crime you can get a discharge without conviction for. The question is whether the conviction would be a disproportionate punishment given the circumstances of the offending and the nature of the offender and so on and so forth. Now, if you're going to make sentencing by definition excessive, by definition unjust, then recourse to discharges without conviction will increase. And that's problematic, because there are circumstances right now where you wouldn't get discharged without conviction, but tomorrow you will. So you're having an opposite effect. And this is the perversity that happens when you go in with a slogan and make it policy. Slogans make bad policy. It may well be that there's work to be done in sentencing. And for a long time there has been an argument that sentencing should be removed from the political arena, but that judges should be given guidance, that they need a unifying principle. On the other side of the House, they would say that there's been this tendency to give softer and softer sentences. Well, is that true or false? Or is it just an impression we have through the media? Well, a sentencing council which looks at sentences. I know the ministers had meetings overseas about the sentencing council, and it's a good idea, because we need to depoliticise this, because we're not making the community safer by just simply having a blanket approach to sentencing. If we are going to say we need better guidance to the judges, then a sentencing council is one way to do it, and a very useful way, where you have the ability to look over all of the decisions being made, see where there are wrinkles, see where there are inconsistencies, and provide guidance and advice that the judges are expected to pick up. So that's a further thing that is well worth consideration. The other thing in here is that there are just some outright injustices. So, for example, the remorse discount. That if you come and you convince the court that you're genuinely remorseful, the court can take that into account and reduce the sentence imposed. And you want to see that it's real. You don't want crocodile tears. I get it. Absolutely appropriate. But you can't get it twice. But there's a carve-out. You can get a discount twice if you provide compensation. So the court can take into account compensation to victims, a payment for the harm that's been caused. So people who can afford to make compensation can effectively get remorse discounts every time they pay. But people who can't afford to make compensation payments can't get those discounts. That's just one of the kind of twisted terms of this Act in trying to pander and not taking a careful, considered, evidence-based approach, not taking the time to develop policy rather than just implementing slogans. We've got a bad piece of legislation. We all want a safer community. We all want victims to be accorded the rights and treated with respect. We want fewer victims overall. And we do want to set aside serious offending and show the community disgust and distaste for it. But this bill doesn't do that. It just increases longer sentences.
I think Duncan's literally summing it up.
That's a summary right there. Copy and paste everywhere. But yeah, he is right. This is a reactionary bill. More should be done to prevent crime, not punish crime. We already do plenty of punishing. We need to be focusing on prevention. In jails, prisons, the ambulance is at the bottom of the cliff, right? We need to figure out how to stop people from jumping off the cliff so we can actually prevent future victims or keeping violent reoffending individuals away from civil society. That is who prisons should ultimately be for. Not for people who commit burglary, but for people who actually beat the shit out of other people and kill them and hurt them in gruesome ways. But yeah, if people can be treated and taken off the pipeline of reoffending, we should be investing in that. We don't need to become a prison state when we have viable alternative options on the table, such as community-based programs and mental health treatments. I will disagree with Duncan on this thing. He says slogans make bad policy. Now, that's not necessarily true. They can be a simple, nifty way to summarize a policy point. But what is true is that slogans don't equal policy. Policy is nuanced, it's complex. But a slogan can give people an idea of what it is you're trying to achieve.
Thanks for watching. Make sure you're subscribed to our Facebook, YouTube, Twitch, Instagram, TikTok, News Guide, The Order Paper Podcast. YouTube, Twitch, Instagram, TikTok, News Guide, The Order Paper